described it the best way I could. Yeah, I mean, this is in effect till, I guess whenever someone the court says, hey, we will allow this, then we can always, or let's say law enforcement can, have it removed. So other than that, it's in effect till whenever.
Just to be very clear, were you required to give Mr. Lawler another warning when he was in the courthouse recording on February 20th, 2024?
No,
Just to be very clear, you observed him personally recording in November and in February, correct?
yes, in November, with his actions with the camera, and then he told me he was recording.
Okay, and I think there was a question on cross-examination about whether it could be any other criminal offenses. In your opinion, could it be disorderly conduct to record within the courthouse?
That was one of the things initially, before I got there.
It's not a legal conclusion, he's trying to interpret statutes, and I'm asking if it could be a crime based on his interpretation of the statutes.
I don't see how that's relevant to what we're addressing.
It was brought up in cross-examination about he was asking if it's an annoyance or the blowhorn,
I didn't necessarily think it was relevant then, but you didn't object, so I don't think so.
so the court is overruling?
Yes.
Okay. You waited to arrest him until after you got confirmation that he was recording, correct?
Yes,
Okay, so when we saw you standing outside the clerk's office, had you made your arrest decision at that point?
is this,
And I'm sorry, we're talking about
Yeah,
the
it-
February incident. You and the other officer, were standing outside the clerk's office, right?
right, yes,
You hadn't gotten confirmation yet that he was indeed recording?
correct,
Okay, and you hadn't made contact with him, correct?
correct.
Did you go back to your office then to wait until you got confirmation from the court staff that he was indeed recording before you made contact with him?
Yes, I was over in my office, I think, obviously went to the court, the employee offices.
Okay,
And at some point, I don't remember if it was in the office or over there, I think it was in the office, our office. And then we were notified that he was indeed recording.
did you confirm just to make sure that he didn't have permission to record from Ms. Cloud or any documents with the court?
That's correct.
Okay, to your knowledge, even after you arrested him back in February, you did a check and there was no indication that he had permission to record.
Yeah, I didn't check, I know the court staff was advised that Mr. Oler was arrested. No one ever provided me any documentation that he had permission from the court.
Okay, so even from the court standpoint, they were not aware that he was given any prior authorization or permission to record?
Correct.
Call for speculation as to what the court knew or didn't know.
If he has personal knowledge, Judge, he can answer the question if court staff were aware.
If court staff were aware that Mr. Lawler was arrested, that he can answer. What was the?
It was about whether he had permission to record, if court staff is aware.
He already said he did not know. He did not seek that information. Here, restate your question.
Trying to think of how I
Well,
asked it.
If you state what was your exact question?
I think Sergeant Long, I asked you, if you were aware of whether he had any permission or authorization to record.
I was never informed by the court, or nothing was ever produced to me that he had permission.
Is that sufficient, Judge? Okay, and then, I think there's some disagreement about what was contained in your body cam, which the court is going to review on its own time, but in your opinion, do you believe you told Mr. Lawler that he could not record inside the courthouse, even if he was there for official court business?
Correct.
Okay, and was there other people in the clerk's office when Mr. Lawler was recording?
Yes,
Okay,
yes there was.
and did we see that in the body cam footage? That there was
Yes,
Your
nothing?
Honor, outside the scope cross.
You asked about him causing disruption, so I'm gonna hold on.
Okay, you can answer the question, Sergeant Long.
Yes, there was, I don't remember what the last question, but there was a gentleman at least to, the left there, not left window.
Okay, and where his phone was, propped up inside the clerk's office, was he recording any individuals or workers behind the desk?
Yes,
Okay, and is that what the presiding order is focusing on with its privacy interests?
yes, I believe so.
Okay, and why do you believe that?
Because like I mentioned earlier, there are certain areas where there's sensitive information or documents that are, being provided, or like the screening area, security measures, or, grand jurors.
And then is it your opinion today that Mr. Lawler was, in violation of the trespass advisement that you had issued him back in November?
Yes.
No further questions.
briefly.
Thank you, Judge.
So, Sergeant Long, when I asked you if he was in violation of a criminal statute, you testified he was not, correct?
Right.
And then when she
Well-
asked you, you said he was.
Just, hold on, sorry. Can he actually have a chance to answer that question?
So,
That's not what his testimony was.
okay. So, a statute versus the trespass statute, we need to be clear. Any other statute besides trespass statute, because
No, Judge, I'm asking him to interpret that stuff, and I believe Your Honor will do a better job than any of us, so I can move on from this whole line of questioning and just ask a couple more.
And I think it's the court's job or a jury's job to interpret the statute. So Officer Long has testified he believed he had probable cause.
There
It's
will
the
be
court.
time for argument.
okay,
I'm just responding to the objection.
yeah, and not allowing the question, so he's moving on.
I'm withdrawing it, I'm moving on. You mentioned an analogy, you talk about how if a business were to call and say they wanted somebody off their property, that they would have law enforcement do that for them. You brought it up a couple times, right? You brought up a business, you brought up a landlord.
Yes.
You'd agree with me that a business is a private enterprise,
Yes,
and that a courthouse is a public place,
correct.
and those are different things.
Yes.
In November, you warned Mr. Lawler that if he kept up doing whatever he was doing, you were gonna trespass him. What did he do when you warned him?
I'm an object judge, so this is just on redirect. And we're way beyond questions that were just in redirect. So these were questions that could have been asked in cross-examination. We're just focusing on redirect, his cross of redirect. And I think we're getting into beyond the scope at this point.
So, this is recross, so I don't even usually allow recross, that I'm allowing it, how is this appropriate in recross?
The state asked Sergeant Long, Sergeant Long, you had no duty to warn him. Sergeant Long said, yeah, I didn't have to warn him before I arrested him in February, because I warned him in November.
Okay, so what is the duty have to do with your current question?
So I'm gonna ask him what happened in November. I anticipate this testimony will be that he warned him and Mr. Lawler left. And then I'm gonna ask him in
I
February,
already have all that information.
and then in February that he didn't warn him and didn't give him a chance to leave.
I don't need him to tell me that, I've seen the video and I already know what happened.
And Mr. Lawler was not given a written trespass, correct?
Objection asked and answered.
No, it was never asked. I had questions about it, but he was never actually asked of the witness.
Your question was Mr. Lawler given a written trespass warning, is that what you said?
Yes.
No.
No further questions, Judge, thank you.
You may sit down.
So do you want?
Yes,
We'll leave it there. Ms. Marks, any other witnesses?
No, Judge.
Mr. Musa?
No, Your Honor.
Witnesses? Alright, so you're not gonna put on the other potential witness?
I didn't subpoena them, I was under the understanding the defense did.
Sergeant Long was rather forthcoming, Judge.
Everything we needed?
We got everything we need.
Alright, then are we ready to go to argument?
Yes, Judge.
Would you like a few minutes to organize your notes?
I don't think so,
Or ready to
Judge. I'm just gonna mostly rely on my briefing. I think everything has been pretty clearly laid out in the briefing. I think there's actually not even a lot of questions in dispute. It's just whether the court thinks that there was probable cause and whether the court thinks the elements of the statute are met here for the motion to dismiss. So I don't think we need to waste time on oral argument. The briefing is very clear from both parties unless the court has specific questions for me.
I have a feeling Mr. Musa's gonna wanna do a closing, so
Okay.
I'm gonna give you the option to do it as well, but,
No, Judge, I think it's pretty clear. And I think especially given that the defense has even stipulated that to a super court. So it's just whether your honor thinks it meets elements of the statute, and whether there was probable cause.
Thanks, Judge. So, Your Honor, we're asking that the case against Mr. Lawler be dismissed because there wasn't a crime committed. The trespass order was a life-imposed sentence upon Mr. Lawler by Sergeant Long, saying he couldn't appear within the courthouse except on official business. He returns on official business. He's arrested without an investigation. Your Honor, the record evidence established that while he was there to process a citation, there was an already a decision made to go 1080 him or arrest him as they walked up to Mr. Lawler, not knowing whether or not he was there on official business or not knowing whether he had permission to record or not, and that's all been testified to here today. And the issue really comes down to us from a legal perspective from the statute 1146-330. And in that statute, it reads that a person commits the crime of criminal trespass in the second degree if the person enters or remains unlawfully in or upon a premises. And then 350 defines what it means to enter or remain unlawfully. And that section reads that as used in 1146-300 to 1146-350, enter or remain unlawfully means to fail to leave the premises that is open to the public after being lawfully directed to do so personally by the person in charge. Sergeant Long testified that he was not the person in charge. Sergeant Long testified that he did it on someone else's behalf. Sergeant Long testified that at no time did Barbara Cloud or anybody else in charge ever personally direct Mr. Lawler to leave the premises. So just based on basic statutory construction, Mr. Lawler was never unlawfully remaining in that public place. Your Honor, the seizure of Mr. Lawler's person and his effects was unlawful because the enforcement lacked the requisite probable cause. And that was because his, Sergeant Long arrested Mr. Lawler. At that time, Sergeant Long did not know if Mr. Lawler was there on official business. Sergeant Long did not know if Mr. Lawler had permission via that TF 945 form. And further, Sergeant Long testified that under the same basis that Sergeant Long records in the courthouse under the body-worn camera exception to the presiding order, that was actually the one in place at the time both these situations occurred.
So is that different than the one that's been,
It is.
new?
It is, Judge.
So I don't have that in evidence.
It was, we were all of us, under the understanding that the one that they provided was the one that was relevant at that time, and then all of a sudden I look it up and there's a newer one, so we've all been operating under an inapplicable
I'm confused what defense is referencing.
order.
So his argument is there's the presiding judge's statewide order, the one entered in June is different than the one that you have entered here in evidence, which is he's.
I don't know what
saying-
he's referencing. I gave defense what was put in the packet for Sergeant Long's incident report and what was provided to defense. I think what he's referencing is not in evidence right now.
Sergeant Long testified that the presiding order that I showed him was the one that was applicable at the time, even though it wasn't the one
Okay,
that.
you showed him you showed him something on your computer that wasn't authenticated. I don't know where that came from. I don't know how I can consider that as
Well,
evidence.
It's because at the time I wasn't using it as evidence, I was impeaching him, that he used the wrong order to trespass.
Okay.
And then he testified
But
that,
if your argument is that he was not violating, don't I need to see that agreement? Is that, where did you find it?
I found it online, Judge, it's an order, it's a presiding order, but it was just an updated one that was issued in.
So it's on the court system's webpage?
Order on video recording, it's 5 pages, it was signed on July 24th, 2023.
Any objection to the court taking under advisement that there is a,
I would object, this wasn't admitted into evidence. We're done with the evidentiary hearing now. He's trying to get in additional evidence.
Just making sure that we're on the same page, that the public presiding judge's order is seeking to be excluded by the state when the state's only witness testified that this was the applicable order. And he didn't know it at the time, but this is the one that applied to both those provisions that Mr. Lawler was arrested for.
I'm not seeking to exclude anything, but during an evidentiary hearing,
so
you
you
have to,
stipulate?
hold on, let me speak. You have to admit evidence. You didn't admit this document into evidence. Now the court is supposed to consider something that's not even in evidence. That's what my objection is.
So are you stipulating to the applicable order that your only witness testified was the one that applied on the 2 dates at issue?
okay. So, you told her this is on the website, she needs a minute to see if this is actually if this is the order that was in effect, I think that is relevant, and I think I do need to consider it, but she needs to be able to figure that out for herself, she can't just,
I showed it to
you
her
can't just
before.
read something.
Agreed.
So,
Reactions.
if you can, what I
Can we
need
take
you
a
to
brief
do.
recess so I can look myself, like I said, there's no exhibit list right now, I asked if he had an exhibit list, if he was planning to bring any exhibits into evidence, I was indicated it was not, so could we take a little time so I can look myself?
If that's what you wanna do, I mean, although I was gonna say I was gonna let him make his argument, and then you can
I would
file
prefer-
something if you
Yeah,
wanted to.
I think that's the best approach, we're already at 154.
Okay, I mean, I don't have hard stop at 2, and I confirm everybody else doesn't, but yes.
And Your Honor,